Hi, everybody. My name is Mike Rappaport, and I'm director of the Center for the Study of Constitutional Originalism. And I would like to welcome everyone to San Diego for the 15th annual You and Hazel Dawling Foundation Works in Progress Conference. The 15th! Every year at the beginning of the conference, I use this time to highlight what I regard as the most important events concerning originalism in the past year. Originalism continues to grow in influence and to be a central topic of constitutional and statutory interpretation. Perhaps the most visible case decided by the Supreme Court in the last year was the Harvard and North Carolina affirmative action case, Students for Fair Admission. The result in that case was extremely significant, but what was the role of originalism? I would say that originalism's influence was mixed. On the one hand, Chief Justice Roberts' majority decision did not really employ originalist reasoning. It had only 2 paragraphs on original meaning and early precedent, so not very much. In this respect, the decision to change the law in an important case, like in the Dobbs abortion case, was not primarily premised on originalism. On the other hand, Justice Thomas's concurring opinion spent many pages arguing that the original meaning of the 14th Amendment prohibited state affirmative action. Critics of Justice Thomas and Justice Scalia had in the past, I think, rightly criticized them for advocating a colorblind constitution without justifying the decision based on the original meaning. But in this case, Thomas's opinion placed originalism in a much more central place in the argument that affirmative action is unconstitutional. Originalism also played an increased role concerning affirmative action in Justice Gorsuch's concurrence, where he argued that the original meaning of Title VI of the Civil Rights Act prohibited all discrimination on the basis of race. And of course, the principal dissent also addressed the original meaning of the 14th Amendment from a different perspective, reading it to allow affirmative action. Thus, while the majority opinion in Students for Fair Admissions did not mainly rely on originalism, originalism played an important role in several opinions in the case. And this is a big change from past decisions in the area. Another very visible case was Biden versus Nebraska, where the Supreme Court held that the Biden administration's student loan forgiveness program was not authorized by the HEROES Act. The court's decision involved an extremely important matter implicating the interpretation of agency statutes, the major questions doctrine. This relatively new Supreme Court doctrine holds that in certain cases where the agency asserts significant authority, the court will require a clear statement authorizing the agency's actions. Initially, the major questions doctrine appeared to be justified as a substantive canon of interpretation, as a means of protecting the substantive value of not allowing excessive delegations. Justice Gorsuch defended this, and the court's majority decisions also seem to suggest it. But in my view, there are serious problems with this argument. If the court has the power to establish new substantive canons, not merely to enforce long-existing canons, then that power is very much like a living constitutionalist approach to statutory interpretation. The court is largely enforcing the values it likes. This is not something that originalist justices ought to be doing. Thus, I've been happy to see originalists push back against the substantive canon approach. In Biden versus Nebraska, Justice Amy Coney Barrett defended a different version of the major questions doctrine as a linguistic canon, as based on how people use the language, which in my view is far more consistent with originalism. Elon Werman has also argued for the linguistic canon, and I have even added my voice. I view this pushback as a commendable effort by originalists to police the actions of other originalists to keep them in conformity with originalism. It shows originalists being willing to sacrifice results to legal principle. Now, to be fair, I do recognize that some originalists defend the substantive canon version of the major questions doctrine. But in my view, the strongest defense of the substantive canon view would rely on conceptualizing interpretive canons as a form of general common law that can slowly evolve to reflect new circumstances. That defense might view the major questions doctrine as an evolved rule that responds to new circumstances, but would not allow judges to assert the power to freely decide which values to protect. Unfortunately, I've not seen a significant defense of the substantive canon approach along these lines. Another important case from the last term was Tyler versus Hennepin County. Hennepin County involved the question whether the government could keep the entire proceeds of the sale of a person's property when the person only owed a portion of the value of the property, only a portion of it. Taxation may not be theft, but this sure seemed like it was. The court concluded that the Takings Clause prohibited the behavior relying on traditional English law as well as early federal and state statutes. While the opinion may not have had a long discussion of the originalist evidence, it represented more originalism than virtually all of the court's decisions under the Takings Clause. So a step in the right direction. One of the most important originalist developments of the past year involves a matter that has only been argued at the Supreme Court yesterday. And that, of course, is the question whether former President Trump is disqualified from serving as president again under Section 3 of the 14th Amendment. The debate in this area has focused primarily, although not exclusively, on the Constitution's original meaning. Thus, most participants in the debate, at least prior to the Supreme Court argument, seem to believe that this enormously important question for our country should be resolved based on the Constitution's original meaning. Significantly, originalists are on both sides of this question, as the debate tomorrow amply illustrates. The large number of questions that are at issue on which originalists have been contending indicates just how contentious issues of original meaning can be, even among those who are engaged in the enterprise in good faith. While this might lead some to question the determinacy of originalism, it is always important to compare it to the alternative. If we were to decide the disqualification question based on political principles, whether the high politics of principle or the low politics of partisanship, the disagreements would be at least as contentious. But more importantly, under originalism, there is concrete evidence in the form of constitutional language and historical meaning that must be addressed. And this provides far more constraint than does either high or low politics. While the Supreme Court decisions have been important, perhaps the past year is most noteworthy for the large number of originalist-oriented cases that have been accepted by the Supreme Court for argument. It's hard to know which of these will be decided on originalist grounds, but they all have been argued, at least in part, based on originalism. Perhaps the most important of these cases are Loper-Bright and Relentless, which raise the question whether Chevron deference should be cut back or eliminated. These cases have been argued in part based on the view that Chevron conflicts with the original meaning of the Administrative Procedure Act and of the Constitution. If Chevron is overruled, that would be quite significant. But there are other important originalist-oriented cases involving administrative agencies. There is Community Financial Services Association versus CFPB involving the limits of the Appropriations Clause, which Christine Chabot will be talking about today. And there is SEC versus Chikarsky, which raises several important questions, but seems destined to be decided on the Seventh Amendment. And finally, there is Moore versus the United States, a tax case which asks whether the federal government can tax unrealized income without apportionment among the states. This involves a significant question concerning the original meaning of the 16th Amendment, one that might have important implications for the constitutionality of a wealth tax. Many of these cases have arisen from circuit court decisions with either majority or dissenting opinions that raise significant originalist questions. These decisions, which identified originalist questions so that the Supreme Court could address them, show the importance of originalism in the inferior courts. Let me conclude by saying that academic originalism has in the past year continued on its strong path. The debate on the original meaning of the Second Amendment is perhaps worthy of special note, but more generally, the recent originalist debates with originalist arguments on both sides of those arguing over whether the Constitution's original meaning gives the president removal authority over executive officials, whether it places significant limits on the delegation of legislative type authority, and on the original meaning of the Privileges or Immunities Clause. These debates continue and are as extensive and significant as any originalist debates have ever been.